Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 119 of the Business SOS podcast. I'm very excited as we continue. Now I'm working towards episode 200, as it is my goal. And I want to thank you for listening to me every week and hope the information I provide to you is helpful to you and your business. If you have any questions or anything you'd like to reach out to me for, my email is richsierra.com. Just want to tell you that at the beginning so that way you have it available if you have any questions. So a common question that I get is that why trials are so expensive. I mean, litigation, we talked about litigation cost at some point throughout the year, but I want to go specifically on the trial and trial preparation. There's a lot of things that happen behind the scenes that clients do not see, do not understand what's going on with the attorneys, the paralegals, co-reporters, and with opposing counsel. And, you know, there's a perception that going to trials, that what you see on TV, you have a TV show starts in the first 15 minutes, then 25 minutes later, you're at trial. I wish it was that way. It is not. On average, a case takes about 18 to 24 months to get resolved. Most cases, as I mentioned to you before, they get resolved before they actually go to trial. In fact, most cases do not go to trial. And I'm talking from the business litigation context, which is what I practice. Most cases, 95 or even I'll say 98% of the cases get resolved either a mediation or through attorney negotiation. A very small percentage go to trial. Why is that? It is very expensive. It is very expensive to go to trial, and it's also very uncertain to go to trial, because when you go to trial, there will be a winner and there will be a loser. There's no draw here. So many parties that are involved in litigation, when they're given the option to resolve the matter on their own terms, at the very least attempt to resolve it on their own terms, they choose that, even if it's not what they expected to have as an outcome, but it's an outcome that they control and they chose. In some cases, the parties cannot agree to resolve it, and they rather have a judge to resolve it if it's a bench trial, or a jury to resolve it if it's a jury trial. And there are a lot of things that go on with preparation. So today what I want to talk about is, you know, the trial order. What do we receive when we get a trial order from the court? And I'm using a sample of a uniform trial order that we received in a case a long time ago, you know, maybe about a year ago. And I'm using that kind of as a format, or give you kind of an idea of what things we have to do in order to prepare for trial. This is usually entered at the beginning of the case. We call them case management orders, scheduling orders. They're different type of names that the courts use, but in essence, what is a roadmap that tells the attorneys and the parties, you are expected to go to trial, say, 18 months from now. And they set a date, what is called calendar call. The calendar call is when the attorneys appear. Now we appear via Zoom. Before we used to go in person to the courthouse and tell the judge whether or not you're ready for trial and how much time do you need? Are there any conflicts? And that's when the court decides when you'll be assigned to the trial period. Generally speaking, what you have in Broward and Miami-Dade and also in Palm Beach, you have trial periods. It could be between 3-week trial period, could be longer. So within that trial period that they assign, you have, it's like a 3-week calendar that the judge reserves a time only to conduct trials. So based on the priority that the judge assigns, usually the older cases are assigned first, then they assign the cases to the particular trial period. So for example, if there's a case, we're 2025, we have, say, a 2022 case, that's going to have priority over the other cases. And then the attorney said we need if it's going to be a 4-day jury trial. So within that 3-week trial period, the judge will assign you're going to be in week 1, week 2, or week 3. And that's just, so that particular case takes already 4 days of that trial period. And then you have 1 day available. There could be an overflow, or perhaps the judge may assign a non-jury bench trial for 1 day just to make sure that day is utilized. So the judges have a challenge here, the judicial assistants in this case, because they're trying to fit in a large amount of cases that are assigned to that trial period in a limited time. So they have 3 weeks, in essence, 15 business days, and you have cases that go 3 to 4 days, and you have, say, 20 cases that are ready for trial. Just mathematically speaking, you can only accommodate maybe 3 or 4 with, when you have backups. And what they usually do is you have like first position, you're going to be number 1 in week 1, for example, and then they'll have a case that is a backup, and because that way, in the case that the first case gets resolved through settlement, or they, usually even before trial, people settle cases, then the court still has another case assigned to move up to that particular time slot to be able to conduct the trial. Otherwise, it'll be 4 weeks with nothing, 4 days with nothing. So the court they do the best they can to try to accommodate and to fit in these cases within the limited time period. But some cases, what happens here is that once that is set, that all the cases are assigned to the trial periods, then the remaining cases are sent to a trial pool. And what that means is that those cases that are ready for trial could be tried by any judge that is available. Some of the judges may have a clearing in their calendar during that time period, said, I'll take that case, I'll try it for you. So it goes into a trial pool. Or in some cases, like happened to us recently, then that is assigned to a senior judge that can try the case. Judge that is not part of that working actively in the court system, in the courthouse, but is available to try cases. And then they assign that to a senior judge, and the senior judge will take over the case. So just want to give you an idea of what just the scheduling challenges that the court has, in terms also that we have, because we got to tell our clients we're going to be within the time period of 3 weeks between October 1st to October 21st. I'm just using that as an example. Okay. And we could be called to trial within 24 to 48 hour period. They said, okay, you're going to be ready. Show up to the courthouse, 9:30 a.m. And then we got to tell our witnesses to show up. We got to tell our clients to show up. And in some cases, the clients are flying from out of state, which presents even a different challenge in trying to coordinate that in a short notice. So what we try to do is ask the court to set it up special set. So I'm just to give you a flavor of just trying to schedule the trial in itself is a challenge. The question is, what happens if there is not enough time for our case to be tried during the trial period? In that particular case, the case gets rolled over to the following trial period. So it's very common for cases to get rolled over because either unavailability of counsel or a conflict, or there's just not enough space. So it's something that, unfortunately, you have to get used to if your case is going to be set for trial, because there's a chance that it might get rolled over for a number of reasons. That could be a podcast in itself, but in essence, it can be rolled over, and it's not uncommon to that happen. So let's go over the uniform trial order to just give you an idea. And what is this? Is a roadmap, and establishes deadlines when things have to be completed by, and so that way there are no surprises when you're showing up to court. And that's also creates a system that is fair for everybody because everybody gets the advance notice of what they're expected to do. And I'll just give you an example of some of those key deadlines that we have to meet in preparation for trial. So an example of that, we have to calendar call. Let me go back for a second. Calendar call, everything goes back from calendar call. And that's the day that you have to be trial ready. If you're not trial ready, you got to let the judge know why, and then the judge will decide what to do at that point. But so everything is from that calendar call date. So, for example, in this case, this trial order that I'm looking at from the 17th Judicial Circuit, the witness list, fact witnesses have to be disclosed 120 days before calendar call. Expert witnesses 90 days before calendar call. Rebuttal witnesses 60 days before calendar call. There's also discovery deadlines that we have to meet, meaning that after a certain point, in fact, by the time you go to a calendar call, you no longer can take depositions. You can no longer do discovery. You cannot send interrogatories without permission from the court. So you have discovery deadlines, and they have to be completed sometimes 30 to 60 days before the actual calendar call. And let's see what else I can tell you about this. Actually, I'm looking at the actual trial order, and I'll tell you exactly what. Yeah, and this one here, 65 days prior to calendar call, all final discovery has been initiated prior to calendar call. The reason for that is because you have 30 days to respond to it. And then all the discovery completed no later than 30 days prior to calendar call. What that means is the discovery has to be done early. Otherwise, you'll miss that opportunity. Now, there's also something called motions, and I've talked about motions before. There are motions for summary judgment, there are motions for challenges of expert witnesses, and I'll give you an example of some of those here. In this case, in this order, no later than 75 days prior to calendar call, all the motions to amend the pleadings, to add new parties, they have to be done. If you don't do it 75 days prior to calendar call, you waive that and you cannot bring that up again. Again, everything has exceptions. If there's some extenuating circumstances, you can ask for leave of court to do that, and the court will determine that. But the objective of this trial order is to have some finality to the process. Because if you don't, this case will continue forever, and that's just not proper. Important deadlines, what is called dispositive motions. Dispositive motions are like motions for summary judgment. This is one of them. In that particular case, you have to do it at the very least in this order 75 days prior to calendar call. The reason for that is because in a motion for summary judgment, and I'll probably do a podcast focusing on that, there's a time requirement by the time you got to set the hearing, and it is 40 days after you file the motion. That's the earliest you can set a hearing for that particular motion. So otherwise, you cannot file it. So just briefly, what a motion for summary judgment means is a motion that you're telling the court that there are no issues of material fact, meaning that based on the testimony of the parties, the witnesses, the deposition, transcripts, the evidence that you gather, interrogatories, there's nothing in dispute that will prevent the court from ruling on your favor. That is what it means. That there's no need to go to a jury trial. There's no need to go to a bench trial, because there's the facts as they're presented, according to, say, we are the plaintiff, we have sufficient evidence to have the court rule, because the other side will not be able to overcome this evidence. And as it would be futile for them to do it, and they don't have enough evidence to overcome the evidence that we have already so far. So we ask the court to rule on that. So the court will look, the court will look at the motion, will look at the evidence. The other side has the opportunity to provide competent counter evidence to establish that there are issues of material fact that would require the court to hear this matter, this particular portion of the case at a trial. And so the burden shifts to whoever the motion is filed against to overcome that. The court will look at that and then decide whether or not, yes, they'll grant the motion for summary judgment. No, will be whether it denies the motion for summary judgment. And in this case, if the motion is denied, then that particular issue goes into a trial. But there's a motion for summary judgment is a great tool to try to dispose of a case and narrow the issues of going to trial. But there are deadlines when you can file that. And the motion has to be heard prior to calendar call. So say you file all these motions, you did all the discovery, you interviewed all your witnesses, and you have your deposition transcripts, and you had your mediation. Another deadline that it is established here is that you have to have mediation 60 days before calendar call. And that's a requirement. Pretty much if you're in a lawsuit in Florida, you will be required to attend mediation at some point. It's not an option. I'm a proponent of mediation, as you heard me before, and I prefer mediations a little bit early in the process to see if there's an opportunity to resolve the issues earlier, sooner. If by any chance they don't, then we know we're going to go to trial. But it gives the opportunity to the parties to see if it can be resolved and avoid the continued payment of legal expenses for the dispute. Oftentimes what happens is that people conduct a mediation conference later in the case, and 60 days before trial, you already have conducted a number of depositions. You spent thousands of dollars in legal fees. You have paid thousands of dollars in deposition transcripts, and the parties sometimes are less motivated to resolve the matter so close to trial because they already have expended so much money in the litigation process. And I've seen it happen. They say, well, we already spent all this money, might as well see what happens. So the incentive of telling them, yeah, it's going to be a lot of money for the litigation, sometimes they say, we already spent the money, so might as well see what's happening. But there's costs there's risk of going to trial and not trying to resolve it. And there's still work that has to be done even 10 days, 10 days before trial, leading to trial, and post-trial. And I'm going to go into that now. So say the case went through the mediation and was not successful, was what is called an impasse, and the parties did not settle. The parties agreed that we will go to trial. So there's a lot of work that has to be done in preparation for that. That's just here in terms of court filings, not including the preparation that has to be done with respect to preparing for trial in and of itself. So I just give you an example. The court requires the attorneys to prepare what is called a joint pretrial stipulation. Again, it's a joint pretrial stipulation. And that is a very important document because that document is kind of a blueprint that the court has for the case. And it's an agreement that the two parties made through attorneys about what is going to be included in this trial. So, a question is, what is included in a joint pretrial stipulation? I'm going to go over some items. The statement of the case is a brief, neutral overview of the dispute about what is the nature of the case. Could be a breach of contract case, could be a defamation case, civil theft. So kind of a summary of what the case is all about. This will help the judge understand, okay, what is this case all about? So that way we provide that information. What are stipulated facts? Number two, we provide stipulated facts. So there might be facts that the attorneys agree upon that are not in dispute. So that will help speed the process up. So the more stipulated facts you have in a case, the better to move things along. An example of that, you're dealing with a breach of contract case. The parties can agree that the contract that is attached to the complaint is valid and enforceable, and the parties agree that that's the contract that was signed. Okay, so that's a stipulated fact. Okay, and in some cases, there's some things that we agree upon that are not in dispute. So the attorneys go through these, and then we go ahead, and then the next thing we do is have a list of the uncontested facts. That's where things that we disagree that will have to go to the court. So the court will focus on that. Okay, so you agree on this. This is why you disagree. You know, whether one party breached the contract, whether the party made the payment or not, whether the services that were agreed upon were delivered. All that is part of an example of something that will be a contested fact, and that will be something that will be presented to the jury or to the judge, depending whether the case is a jury trial or a bench trial. So we provide that list. Then the exhibit list. So you have the plaintiff's exhibit list, and then you have the defendant's exhibit list. So we provide a list of the exhibits that we intend to use at trial. We provide a list of those, and the defense will provide a list of those. What the court asks us to do is, to the extent that is possible, agree in which exhibits are joint, meaning that to avoid duplication. And I have a case now that we have nearly, over 1,000 exhibits, when you look at the number of documents. So in order not to present the same document twice, if there are documents that we both agree that, there's documents that will be used by both of us, then we agree this will be joint exhibits. Anyone can use them. You can also use the plaintiff exhibits or vice versa, but we can agree these exhibits are joints. For example, a contract that both parties sign could be a joint exhibit, so that we don't have two different exhibits with the same information. Now, each exhibit has to be agreed upon, has to be not agreed upon, has to be marked properly, and then will be sent to the court. And in fact, I think next week after the courthouse to bring exhibits that I intend to use for a trial, that will be already pre-marked and be given to the clerk. A decision the attorneys have to make, and the court likes for us to agree on that beforehand, is which exhibits are we stipulating that all the exhibits will be admissible, meaning that we're not going to have at the trial objections on specific documents that we intend to bring in as evidence. So the court would like us to agree which exhibits are stipulated to be admissible evidence. And if there are some exhibits that we disagree upon, then the court would like to know that, so that we can bring it up to the court, maybe at a pretrial conference, and then decide, okay, this exhibit will be admissible, this will not. So that way, that helps the court move the case forward faster. Now, also something else that we have to provide in addition to the exhibit list, and now these exhibits also are provided to counsel beforehand, so there's no, there will be no surprises with respect to, I did not know about that exhibit. In fact, there are no surprises in business litigation or civil litigation. All the exhibits pretty much are pre-marked in advance, and everybody knows about them. So that is provided in advance, and it's actually more efficient that way. if we plan to use any demonstrative exhibits, any type of charts, any graphs, those have to be provided to counsel as well and agreed upon that, yes, that will be a chart that you can use. An example will be, instead of providing, 100 pages of different bank statements and documents, financials, maybe a chart that has a summary of that information will be more concise and containing the same information, but more presentable, more easy to explain, and that's a demonstrative exhibit. And if counsel agrees it can be used, if counsel agrees, then the court can determine whether or not it can be used. So this is, if you get the idea of what we're trying to do here, the court wants us to do as much as possible in advance of going to trial. That it's also for efficiency as well. Because if you're going to be marking exhibits at trial, you're going to be deciding which ones are going to be admissible, not admissible beforehand. It's going to take the court's time and also the jury's time. And the juries are there because they're compelled to be there. So the more efficient a trial is run, the better for everyone. It's also helpful for the lawyers as well. A witness list that has to be provided by the both counsels, by the attorneys for the defense and for the plaintiff. And if they're witnesses that we object to, that has to be brought in advance. But for the most part, everybody will know who the witnesses are because we very likely have taken depositions of these witnesses beforehand. Whether or not a witness will be challenged or it will not be admitted, that's something that will be done through motions. And also whether or not a witness will be designated as an expert, there will be any type of challenges to that expert. Again, challenges to expert are called Daubert challenges, against Daubert challenges, and that's usually done beforehand, before actually you go into the trial. It's not done after, but you designate a witness and an expert, you put it in the witness list as well. So everybody will know the exhibits, everyone will know the witnesses, and you're probably saying, well, if you know everything, what is going to be, everybody knows what each other's going to do. Yes and no. Okay. Everybody's going to present their position, and how you utilize that evidence, how you present that evidence, that's where the skill of the attorney comes in. Because there are no surprises, very few surprises in this type of litigation. However, you don't know what the witness is going to say, even though you have a transcript of the deposition. Anything can happen. We're dealing with live testimony. So there's always this degree of uncertainty and surprise, but this also makes it very predictable of what someone is going to say when they're providing live testimony. If the case is going to go to a jury, then you have jury instructions that are provided. And the attorneys will work together in developing joint jury instructions to the point that they can. And there are different forms that are used. There are standard Florida Supreme Court forms that is utilized. But we provide the court with the actual script of what the judge is going to say with the jury instructions. Now, if the attorneys cannot agree on that, then we present two sets of jury instructions, and then the court can determine which one he or she would like to utilize. It takes some time to do that. We'd like the court to know also if there are any type of pending motions, anything that has been filed with the court, but for whatever reason has not been adjudicated, ruled upon. We let the court know we have these motions that still have been pending, that have not been ruled upon. Usually you might have a motion for summary judgment. You might have a motion in limine, and a motion for limine is a motion to exclude certain testimony from a witness, or exclude certain exhibit, or exclude certain evidence, or limit. So those motions are usually pending at that time, and then the court decides whether it wants to have a separate hearing or if they want to do it at the beginning of the trial. We provide the trial estimate, how many days the trial will take. The attorneys will talk based on the number of witnesses, based on the number of exhibits, documents, opening statement, closing statement. Then we'll provide a best estimate of how much time we need from the court to complete the trial. So the court will take that into account in determining how much time to allocate and for the trial, especially with their calendar. Another thing that we include here is, if there you have a jury trial, how many challenges is called peremptory challenges, and how many of those will each party will agree to have. And these challenges are peremptory. I'm going to spell it PEREMPTORI challenges. Peremptory challenges is basically how many jurors can you disqualify from serving in the jury. And there have to be grounds for that, but you have a certain number. It could be 3 each side, depends. But you agree on that beforehand. So that is basically sent to the court as what is called Joint Pretrial Stipulation. The attorneys, usually what happens in this case practically is that one attorney takes the lead in preparing that first draft of the document. Then the other attorney looks at it and makes changes to it. And there's a lot of back and forth in the process. If there's something they need to get on the phone and discuss, they'll get on the phone and discuss, I want to talk about this point, see if we can get it resolved. If not, we have to put a statement there that plaintiff, and that's usually in the incontested fact. Plaintiff believes this is not a contested fact. Defense believes that is a contested fact. So if something we disagree on, we put it there as well. We prepare this document that is very comprehensive. We both sign it, then we send it to the court. The court in calendar call looks at that and that gives the court a blueprint of how this trial is going to run and the time that is allocated. Very, very often the court says, would you like to go to mediation again to see if this can get resolved? Sometimes the attorney says yes, sometimes they say no, but the court is trying to see, can this be resolved beforehand? Say you go to trial, and usually there's more activity in the trial. There's trial preparation that goes beforehand. The attorney has to review all the exhibits, all the depositions, transcripts, prepare the client for the direct and cross-examination, make sure the witnesses are available. And it's very often, once the trial ends, sometimes the judges, if it's a jury trial, you'll get a decision right there and then. If it's a bench trial, it is often the case that the judge reserves ruling to be able to see all the evidence, especially if it's 2 or 3 days of testimony and documents, and will ask the attorneys to present proposed orders, proposed final judgments. So in that case, the attorneys have to order the transcripts of the trial transcript, and then, in essence, tell the court, prepare an comprehensive order of what happened at the trial and ruling on if it's the plaintiff's favor, the defense favor, but in essence, retrying the case or revisiting the case or what happened the last 3 or 4 days from the transcript, from the evidence that was submitted into the order. So there's work to be done right after the trial. So, but I'll leave you with that. I think that, my point we hear is that there's a lot of moving parts when you're going to trial. A lot of this coordination is done between attorneys, paralegals, and the court staff, the judicial assistant, and also coordinating vendors. If it's audiovisual vendors, you got to hire coordinating co-reporters. A lot of this movement gearing up for that trial date happens behind the scenes. And it's, in essence, the attorney's focus becomes the trial. And that also becomes very expensive because, you're saying, what about all the stuff that we did before? Well, it's going to come to a head now. We had to prepare it and package it and organize it in such a way that it can be presented to the judge or the jury. So I want to share that with you, so that way when your attorney's talking about trial preparation, you have a better idea of what goes on behind the scenes, and not be surprised. And again, the attorney can share with you the pretrial order and the type of work that has to be done for this. I hope this information was helpful to you, so you have a little bit more behind the scenes look of trial preparation. If you have any questions about any topics that we talked about, including today, you can send me an email at rich@richsierra.com. If you want to give us a call, my number is 866-842-5202. If you want to check out our legal services, my website is floridasmallbusinesslegalcenter.com. If you want to watch this YouTube, podcast in YouTube channel, we're on youtube.com/@RichardSierra. We're also on Instagram and Facebook at FSB Legal. Remember, my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.